All right, I think we are on now the motion to strike the individual statutory aggravators. I will give each side 25 minutes, and you can address them in whatever proportion you like within that.
Okay, Judge, I will be covering heinous, atrocious, and cruel utter disregard, and then I will do multi-murders, and Ms. Taylor will do future dangerous. So I'll basically do the next three, and given the time that you've asked, I'm assuming there will be less questions.
I will try to restrain my curiosity.
Right. I'm happy to engage with you.
As you know, I gave you some additional time, and that says why.
Right,
Why.
thank you. We are asking that the court strike the aggravator, especially heinous, atrocious, and cruel, manifesting extreme depravity. And I want to focus, I think I just want to start really focused on how this is different than Hall. You know, we're aware that Hall, Arave versus Levitt, there's a lot of discussion about having addressed this aggravator before. We are framing it for you in our argument in a different way. And so what I want to show are the distinctions is that, you know, Hall was, a decision was issued in 2018, so was Hidalgo. So when Hall issued their decision, the arguments hadn't been framed in light of what we just argued about Hidalgo and that eligibility narrowing. Also, there was no equal protection argument, no argument regarding Article 2, Section 1 of the Idaho Constitution. One of the cruxes of this argument is that what the Idaho Supreme Court and the Idaho courts do with this aggravator is they've created a jury instruction that is construction, also known as, and called in our briefing, judicial gloss. Our argument is that Osborne is from 1981. That's when the judicial gloss was applied, and then recently the Idaho Supreme Court adopted and adopted instructions related to this. But what happened in 2011 is that the Idaho Supreme Court issued the Verska versus St. Alphonsus decision, and in that decision, the court said, this court has consistently adhered to the primary canon of statutory construction that where the language of the statute is unambiguous, the clear expressed intent of the legislature must be given effect, and there is no occasion for construction. And the courts have not taken that into consideration. So if the statute is unambiguous, then it should be given its direct meaning, which we quoted in our brief, would be heinous means utterly odious or wicked, atrocious means horrifying, wicked, and cruel means willfully causing pain or suffering to others or feeling no concern about it. And if it is ambiguous, then under Verska, the judicial gloss should not be allowed.
If it is ambiguous?
If it's unambiguous, then the judicial gloss should not be allowed. But what, the state is arguing that it is, has not argued that it's an ambiguous statute, because that would give us grounds for the argument that it should be stricken from as an aggravator as arbitrary and capricious. And so we are asking that you take into consideration the way that we are framing this argument, which is different than it was in Hall.
Ambiguous and vague.
Pardon?
Difference between ambiguous and vague.
I don't know that I can necessarily draw just a distinction there. I think that they're, similar. Yeah.
So let's do all of yours, and then we'll do all of theirs. I think it goes faster that way. If we do this back and forth, I think it takes longer. They can take notes.
So utter disregard falls under the same argument. The one thing that I want to point out about utter disregard is that Idaho is the only state that has that as an aggravator. But when you look at other states, there's language that is found that is the same as heinous, atrocious, and cruel, which is interesting because it looks like almost we have the same aggravator labeled as two different things. And we also raise the argument there that it's a separation of powers violation when there is construction on that statute, and that violates VRSCA. The next one that I am going to cover is the multi-victims aggravator. Idaho is the only state that has both a multi-victim and propensity aggravator. A multi-victim aggravator is clear. We were having that discussion between clear and fuzzy. Multi-aggravator is clear, 1 + 1 = 2. The irony in some of that is that it seems to lessen the value of a single human life, but it still doesn't tell us anything about the culpability of the person who has been charged with the crime.
Well, isn't it more culpable to kill 2 people than 1?
I think that the issue is, the problem is that it is.
Isn't it a morally more problematic, the number of lives you take?
I think that it depends on, first of all, I want to start answering that question by saying any life taken.
I agree. And,
Right.
Right. And the floor is pretty high, but what I'm saying, doesn't that bring you above the floor?
I think that it depends on the underlying facts of what is the result, what's the basis of how multiple occurs. And so, just to say that the number of people relates to culpability, I think that what the argument that we're making is that supports the other aggravator of propensity. And under Idaho's, the method of selection with a jury and rules about double counting, while the jury can take into consideration the same facts for multiple aggravators, there must be more than one fact per aggravator so that there's not double counting. And that is the problem when you've got a multi-victim aggravator and you also have a propensity aggravator. And there's been, as we cited.
Is that a constitutional problem or an evidence problem?
It becomes a Eighth Amendment constitutional problem when a jury has an inability to properly distinguish between those issues in finding aggravators beyond a reasonable doubt.
I mean, as the gatekeeper, I assume that if the state hasn't provided additional evidence that would support propensity that is not included within the multiple murders, then that aggravator wouldn't go to the jury, right?
Well, I mean, we would hope that the gatekeeper would do that. Yes, Judge, we're asking you to be the gatekeeper now and prevent us from even getting to that question because of the problem that is identified. And we provided the court with law review articles where the issue has been studied about how impactful multi-victim facts are into the ultimate decision regarding aggravators. I also wanted to point out that there are multiple states with a multiple out of aggravate that have that multi-aggravator, but they don't have future dangerousness, which Ms. Taylor will talk about, and that is very related to propensity. And those states are Alabama, California, Kansas, Montana, Tennessee, and Utah. And in fact, Texas is a good example of, it's a part of the definition of capital crime, and then the jury has to decide on the aggravator of propensity after that has been included as part of the narrowing in the Texas statute. So for those reasons, we'd ask that you strike the multiple aggravator as well.
Your Honor, we're asking the court to strike the aggravator of future dangerousness or propensity, whichever label we want to put on it, but it's found in subsection I of 1925-19, subsection 9. And I think when we're thinking about the constitutional way this is laid out to be protective of the Eighth Amendment, to have a true narrowing, and it can't be vague. We've been talking about that all day, so I won't go into that again. But with that in mind, I want to read the words of this aggravator for the court. That the defendant, by his conduct, whether such conduct was before, during, or after the commission of the murder at hand, has exhibited a propensity to commit murder, which will probably constitute a continuing threat to society. That language does nothing to narrow. I'll skip right to the vague part of the argument. We're asking the court to consider three things in striking this aggravator. It isn't narrow, it's very vague, and it doesn't go to the culpability of the crime that's been charged and, if this happens, convicted of. Your Honor, this language, I think, has been acknowledged by our Idaho Supreme Court as needing the gloss in Creech. And I would say that what's required is that the statute, which Idaho doesn't have, has to provide the narrowing, or the sentencing structure, and those things are legislative processes. And that hasn't happened. We have the gloss from the Supreme Court. The gloss that the Supreme Court has put on this, though, does not do anything but loop us back to the statutes that define murder and then exclude voluntary manslaughter. If truly we are to have an aggravator that selects out the worst of people who have been convicted of murder, this does not do that. The language in this aggravator is incredibly vague. When you think about really what is going to happen in front of a jury, they're going to get all this evidence that is supposed to be proven beyond a reasonable doubt. I trust the court will instruct them on that. But then they get this evidence that probably will make them believe that person's a future danger. The chance for a jury to misunderstand the call and the burden that needs to happen is really great. By the language alone, and Creech really doesn't do anything to help. The gloss that gets put on, the jury instruction that gets put on, doesn't help. That just says people.
Did Hall say that it was okay? I can't remember if they addressed that in Hall. I think they did.
I think Hall did say it was okay.
So what am I to do about that?
You are to listen to that, allow me to make my record, which I am, but you are to say nobody else has talked to me about the real language in here when it says probably. That is confusing to a jury. This isn't a judge's call any longer, but this is confusing to a jury to have those words in there. And the chance to find this aggravator, either based on one of the other aggravators, which we know cannot happen, or at a lesser burden because of the word probably, you're to find that is way too vague. And you should strike this aggravator because of that. Additionally, while we're talking about vague, there's a lot of potential for the jury to misuse mitigating factors and make them into future dangerousness aggravators. And
Isn't that the truth, the possibility always in sentencing? I mean, one man's aggravator is another man's mitigator. And I think you pointed it out well in your brief of mental health, right? But isn't that the nature of individualized sentencing and the consideration of those factors?
I think it is a danger. And I can't square in my mind how I am to do my ethical duty to my client and to abide by the guidelines that are set forth in capital cases and do an investigation into mental health and then turn it over like Idaho says I must, and then subject my client to the state's expert to grill him for however long. I mean, I have this duty. My client has the right to present this. But now I have to do all of this and give all of that information up so the state can use it in an aggravator that says, just tell me that the person will probably be dangerous in the future. That is just terrible, Judge. And for that reason alone, you should strike this aggravator. The last comment I'll make is that future dangerousness doesn't go to the conduct, the culpability of the conduct that has happened. And that's really what these aggravators need to do to narrow properly the scope of who's who. I can't tell you the number of times I've sat in court and listened to a prosecutor talk about at sentencing that my client or my client's acts are the worst they've ever seen. And that can't be true when you sit in court day after day after day and you hear that about person after person after person. This statute doesn't do anything to help a jury decide who's the worst of the worst. This aggravator absolutely has to be struck. It's a violation of the 8th Amendment.
Thank you.
Your Honor, beginning with the heinous, and atrocious, and cruel, this aggravator specifically has been upheld by the Idaho Supreme Court, and specifically the judicial gloss placed on this aggravator in Osborne.
Was
Now,
Paul a jury determination? You know?
I'm not sure on that, Your Honor, off the top of my head. I apologize.
I think it was, but I don't recall specifically. Notwithstanding the fact that I think that I'm the actual judge on the case now, I don't recall, because that issue hasn't come up, but.
Thank you, Your Honor. And I apologize. The defendant has raised this argument that in Verska, the Idaho Supreme Court's decision stating that the court would not rewrite or void an unambiguous statute is essentially the same thing as stating that the Idaho Supreme Court is saying that we can't put a gloss on a statute. But those two things are very different, because placing a gloss on a statute to ensure its constitutionality is not the same as rewriting or voiding a statute. If Verska is taken to that extreme, then courts can't interpret statutes at all, and that's not the holding of Verska. Verska simply stood for the proposition that the court was declining to rewrite or void a statute. And of course, the Idaho Supreme Court has never rewritten the heinous, atrocious, and cruel aggravator or the utter disregard aggravator or any of these aggravators. They've simply placed a judicial gloss. As to the future dangerousness and propensity one, which was the most recently addressed, that too has been upheld by the Idaho Supreme Court in State versus Creech. The propriety of considering future dangerousness has been upheld by the United States Supreme Court in Jurek versus Texas. In their propensity argument, their future dangerous argument, the defendant is essentially asking this court to start with a proposition that a jury is not going to be able to follow the court's instructions. And of course, we can't start with that proposition because juries are presumed under Idaho law to follow the instructions that they're given. And that is another issue. That issue is also true in the defense's multiple victims argument. Their argument with multiple victims really doesn't cite to any case law. It's simply based on the fact that they're assuming that a jury is unable to distinguish between propensity and multiple victims. And again, the court is being asked to start with the presumption that a jury won't be able to follow the law. And that's contrary to the state of the law. We can't presume that because juries are presumed to follow the law. Additionally, we also can't start with the presumption that the state is going to just put on the same evidence for all these aggravators. The court should also assume that the state will put on an independent basis for each of these aggravators during the penalty phase. That's our legal obligation, and the jury will be instructed as to what the law is. They will be instructed that they can't double weigh or double count. That's very clear in the case law. The state would just ask that the court decline to presume that the state will present the evidence in a way that's contrary to law and that the jurors then won't follow the instructions. That can't be, Your Honor. So the state would ask the court to deny the defendant's motion as to these aggravators. All of these aggravators have been upheld, specifically the hack along with utter disregard and future dangerousness. There is case law directly on point that is binding on this court. We would ask the court to deny their motion.
Thank you.
Judge, to answer your question about Hall, Hall was originally sentenced by a judge, and then the sentencing was retried, and Mr. Chastain and Ms. Christensen handled that case.
My memory came back to me between then and now, so thank you for clarifying that.
Yeah. I want to point out that Verska says, if it's socially or economically unsound, the power to correct is the legislature's, not the judiciary's. If it needs fixed with construction, as we argue that it does, it must be stricken. And I want to address the question that you asked about why not wait until the evidence comes in and I can strike the aggravator at that time. It goes to the point of why we are arguing all of these right now. There's a huge difference between picking a death-qualified jury and a non-capital qualified jury.
Well, but that just went to my point of your argument presumes I would strike all of them. If, for example, I were just looking at multiple murders versus propensity and those two so overlap that you can't have both, you could still have one, or you could have both, but if there's not evidence independent of one, then you would strike the one.
So you're correct that we are asking you to strike all of them so that we don't have to pick a death-qualified jury, because death-qualified juries are highly likely to convict in the guilt-innocence phase. So we are very, very concerned about that and the fact that that is so different in a death penalty case. But to the extent that you might strike some and save one, for example, the multi-aggravator, there's a vast difference in what happens in front of the jury in the selection phase with that aggravator versus the others that we are asking you to strike. Thank you.
Thank you.
Your Honor, I certainly didn't mean to tell the court that I would presume whatever jury we end up with won't follow the law. What I'm saying is that that particular statute, the future dangerousness statute, is really tricky. It's tricky because of the use of the word probably. It's tricky with the rest of the wording too, and based on the information that will likely come in. I point out that when it was up to a judge to decide, I think a judge is well-versed in what does beyond a reasonable doubt mean and what is a probability. The court looks at that all day, every day, and those are hard concepts for a judge.
Standard would be that the jury would have to be convinced beyond a reasonable doubt that it is probable that the defendant would be likely, or it is probable that they would kill again. I think is the way that that washes out.
I think that's the way it washes out too. And I think it's just a problem with the word probably in there. So when a judge was doing this, it was less of a problem, but I still think there's issues with that particular aggravator. And I would point out that the higher courts in Idaho have recognized the problem. That's why the decision in Creech put a gloss on it. And I think when the courts recognize that that's a problem and there needs to be a gloss or a fix put to it, that's one thing for the court to consider. How the fix was done, I think, is a problem. It's a jury instruction, not by the legislature. But keep in mind, there's a problem with this instruction, or with this aggravator. It needs to be fixed. But the fix is to loop back to statutes that already exist. And I don't really think that's a fix. And I'll stop there.
All right, I think the non-statutory aggravators is the next issue for our attention. And so with that, I'll hear from defense.
Thank you, Judge. Your Honor, by way of housekeeping with the non-statutory aggravators, I understood the state's response briefing to say that they agree that they have to provide notice and any discovery about non-statutory aggravators as well.
They said that they would, is what they had said they would.
Yes. So I think I don't have to argue about that. I think I'm limited to arguing about the burden of proof required for non-statutory aggravators.
Arguing for the state on that issue?
Yeah, Your Honor, the state's position is that the statute clearly says that Rule 16 applies. We agree Rule 16 applies and we'll comply with Rule 16.
All right.
I'll limit my comments then to burden of proof. Your Honor, our position is that non-statutory aggravators need to be proven beyond a reasonable doubt as well. We know that the state can use non-statutory aggravators to help them establish aggravators beyond a reasonable doubt. And looking at the court's new jury instructions that just came out, beyond a reasonable doubt is all over those. When we're talking about aggravators, there's no question there. Those jury instructions are silent on non-statutory aggravators. So I can't lean on those to say that the court should find that these have to be proven beyond a reasonable doubt. But from a fairness standpoint and from a it just makes sense standpoint, you should say they have to be proven beyond a reasonable doubt. I'm thinking about this in the context of having a jury and having the prosecutor producing evidence and arguing beyond a reasonable doubt, but having these other non-statutory aggravators and say, these are things that we have that you should consider, but we don't have to prove these to you beyond a reasonable doubt. I think there's a real danger in a lack of confidence in the finding of an aggravator if you don't require them to prove the non-statutory aggravators beyond a reasonable doubt, just like their statutory aggravators. Capital cases are a really big deal. And if we're going to get all the way to the end of this, and that's where we're at, the court has to have confidence in what's presented to the jury. Mr. Kohberger has a right, if that's where we end up in his case, to have a jury finding any single aggravator they might find beyond a reasonable doubt. And we think you should order the state to meet that burden if they're going to present non-statutory aggravators.
Thank you, Your Honor. I want to start by just, I tried to be very careful in my brief to refer to it as non-statutory aggravating evidence because I'm not sure what a non-statutory aggravator is. I want to be clear, the state's under no impression that there's some shadow list of aggravators that it can prove one of those and that qualifies the defendant for the death penalty. We are, of course, required to prove beyond a reasonable doubt one of the statutory aggravators. And I think what we're talking about here is just non-statutory aggravating evidence. So evidence that may not be, and if I'm being,
So if you look at like a scale, right? And the defense puts on evidence of mitigation, and the state has to put on at a minimum evidence beyond a reasonable doubt of a statutory aggravating evidence. When you go to weigh, does your non-statutory aggravating evidence go on the scale when that weighing is done?
yes, Your Honor, and I think that that's clear from the Hall decision when they talked about this. They talked about they talked about the Zant decision from the United States Supreme Court and how it's important that juries understand when they're making that, when we get to the individualized determination of is death appropriate in this case, it's important that the jury have a wide array of information. That's the purpose of the statute, is what the Idaho Supreme Court said. So yes, I think at that point, any aggravating evidence that has been presented goes on that scale. Now, to be candid with the court, in my mind, anything that's relevant to a statutory aggravating factor isn't non-statutory aggravating evidence because it's relevant to the aggravating factor. And just to be frank, I can't even come up with a good example of what the state would put on in this case that would qualify as not relevant to an aggravating circumstance, but relevant to the overall weighing process. I guess my point is I don't know that this is going to be an issue, given that we will, of course, comply with discovery. We will provide everything that they'll know what we're going to say before we say it. And if there's an issue, we can raise it at that time and discuss, is this actually relevant to a statutory aggravator or not? And if not, does it fit into what I consider to be a very narrow category of non-statutory aggravating evidence that is still somehow relevant to the overall decision, but not one of the aggravators?
I think the visual using my scale would be to get on the scale, the statutory aggravating evidence would have to have been proven beyond a reasonable doubt, right? That is, you have the existence of that aggravator would have to have been proven beyond a reasonable doubt. As I understand the non-statutory aggravating evidence, the existence of that evidence would need to be proven only by a preponderance of the evidence. Is that your understanding?
You know, I don't know that I would completely agree with that because I don't know that that's laid out in the instructions that it's to any specific burden. I think if you look at the jury instruction 1722 on jury deliberation, it talks about finding the statutory aggravator beyond a reasonable doubt. And then when it gets to weighing, what it says is you must each decide for yourself whether all mitigating factors presented when weighed against each statutory aggravating circumstance proven by the state are sufficiently compelling to make the imposition of the death penalty unjust. You do not have to unanimously agree upon what mitigating circumstances exist. The existence of mitigating factors need not be proven beyond a reasonable doubt. You must each decide for yourself whether mitigating circumstances exist, and if so, then consider them in your individual weighing process.
Right, those are the mitigating.
Correct, but I think what I'm getting at is that's what we have in terms of the instructions of this weighing, is it's saying to the jurors, you're going to conduct kind of an individual weighing process to decide whether it's just or unjust in this circumstance. And that's the point where these things would come on scale, to use your analogy. And so I just don't know if there's a point where you would instruct the jury, you know, you heard from witness X, they said A, B, and C. You can only consider that if you find that A, B, and C is true beyond a reasonable doubt. I don't see an instruction for that anywhere. I don't think that's typically how you do sentencing. You know, they would put on their mitigation. Maybe we have some rebuttal to that mitigation that you might consider non-statutory aggravating. But then again, it specifically tells the jury you do not have to find mitigating beyond a reasonable doubt. So my point is, both in the mitigating evidence and in this non-statutory aggravating evidence, there isn't a standard that's given to the jury. And I think that is what was intended by the instructions. Now, we could debate whether that's the right call or not, but I think that's what the statute calls for. I think that's what the instructions call for, and I think that that's the process that we should follow. Recognizing, of course, this court's role as a gatekeeper to what gets heard at all. the fact that we'll be complying with the rules of discovery and they can bring up any objections that they want beforehand, I don't know that that this will be an issue in the case. Unless there are any other questions, we would ask that you deny the motion. Thank you, Your Honor.
Your Honor, I would start by saying I thought I heard the state get really close to saying they're not planning to produce any non-statutory aggravators or non-statutory aggravating evidence, whichever way you want to talk about that, which might be really good. It might save the court having to make the decision if they get all the way there. I would say, though, there's not a statutory list of non-statutory aggravators, but in Hall, it talked about, that decision talked about things in a person's background, if they had a prior criminal history, things about their character. And a prior criminal history, that's fairly definitive. Either you have one or you don't, right? But things about a person's background, that's where it gets really questionable. Are we talking about people's opinions, people that maybe would have an axe to bear with the person that they're talking about? So I think that when you consider what Hall talked about as a non-statutory aggravator, it becomes really important that the state have the burden of proof of beyond a reasonable doubt for those. I would just close by saying that Gardner versus Florida talked about why we have notice and that reliability matters, but it's the same thing on this kind of information, this kind of evidence, these kind of non-statutory aggravators that get produced. It has to be reliable, and the court has to be able to rely on what a jury comes up with. And Mr. Kohberger has a right to have information come in fairly, to have notice of that information, and for the state to carry the burden. And they need to carry the burden if they want to present non-statutory aggravating evidence. Thank you.
Thank you. All right. You're okay with it. I'm going to swap 8 and 9, just because I could see 8 potentially going a little bit longer than 9, and so, well,
Your Honor, can I
Yeah.
help in that?
yeah.
If the court takes the first part of 9, the speedy trial issue, that's the one I'm handling. And I think we've got Jay that's ready on the rest of them. We can cover it, but he's really close.
So he's not here. All right, well, let's start then with 8, contemporary standards of decency.
That's the one that Mr. Logston
Oh, he
would
is.
be here. I've got Speedy.
Do you have, who has trifurcation?
Jay's the one that's the most prepared on trifurcation.
So you've got Speedy. Let's start with that then.
I can do that. Thank you, Judge.
Your Honor, we're asking the court to strike the death penalty in this case based on a conflict of constitutional rights and Mr. Kohberger having to face the choice between holding on to one constitutional right at the expense of another. And that's what's happened here. He has had to choose between his 2 constitutional rights, and those were effective assistance of counsel or speedy trial. Mr. Logston wrote the brief on this, and he did a really good job with the history and why we should look at Idaho's speedy trial, constitutional guarantees of speedy trial, in the same time frame that the statute, 1935-01, says. I'm not going to go into all of that again, because really this is about the choice of picking between constitutional rights.
It seems to not to go into history that your argument essentially asks the court to equate what the pre-constitutional statutory standards were as then constitutional standards. And I think the court has said that that's not the case. Am I wrong about that?
I'm not sure I'm following what the court's asking me. I'm
So
sorry.
it seems that you're asking the court to equate what the statute said about speedy rights for the Constitution, Idaho Constitution provided for it, and treat that as the constitutional standard and grafting it into the constitutional standard.
I would say that it's there to provide guidance because there was that the statute we have now is after the Constitution. The territorial statutes were before we had the Constitution. And when Idaho wrote its Constitution and said, we guarantee defendants a right to a speedy trial, there was that already in mind. I don't think our Constitution says it's 6 months to the day and it's over after that. I don't think that at all. But I think that what was a speedy trial would have influenced a speedy trial right. I do not think our Constitution says it has to be 6 months. But I think our statute does now, and our statute derived from an older statute. And I think that statute, well, I know that statute predated our Constitution. And I think it influenced the writers of the Constitution as a guideline, as a limit. We also know that speedy trial you can go beyond the statutory time frame, and you can stretch that out in different circumstances for different reasons. And our argument is less about that. That's not the argument. The argument is the choice that Mr. Kohberger faced in August of 2023 when he had to choose to continue his case, thereby giving up his speedy trial rights, or go to trial on October 2nd of 2023, 10 months after being charged with this case, with completely unprepared counsel. And that's really the crux of this argument. And the remedy is for the court to strike the death penalty because Mr. Kohberger had to choose between rights, reinstate Speedy, and reset a sooner trial date. That's the remedy. I want to talk about what happened and why Mr. Kohberger had to continue his case. The court's already heard a little bit today about the duties of counsel in a capital case and the kinds of investigations we must launch immediately. It's not just about the facts of the case, but it's also about the facts of the case. But the mitigation phase has to be launched whether or not you ever end up with a conviction. That work has to be done. That's the way it works, and it takes time to do that. You have to find experts, you have to find records, and it takes time to do those things as well. So, and discovery can be a really big deal, and I think the court is probably starting to understand just how big of a deal that is. Last August of 2023, when we were in that place where we had to make that decision, and there was a scheduling order from the prior court in this case that told us you have to continue it by this deadline, by this date, or you can't continue it and you're just going to go to trial. So I think we're positioned a little bit differently when we are truly in a place we have to give up one right to have another right. Had Mr. Kohberger gone to trial and stood on that right, his speedy trial right, and lost his right to effective assistance of counsel, there would have been more than a year's worth of discovery that his counsel would have not been able to know about. We have continued to get discovery. I think there's a bit more that continues to trickle in even past the deadline. I'm not arguing about that right now, but it's just a vast amount of information that Mr. Kohberger would have not had counsel prepared for. We do not have a mitigation investigation completed. We're in process with that still, a year and 2 months after that deadline. So he would not have had that to benefit him either. I think one of the most important things the court should think about when we think about Mr. Kohberger having to choose between his constitutional rights is that we're here right now because he couldn't get a fair jury in Latah County. And if we'd gone to trial in October of 2023, he would have maybe held on to his speedy trial rights. Well, he would have held on to his speedy trial rights, but he would have given up his right to effective assistance of counsel and his right to a fair and impartial jury.
What's wrong with the idea of Speedy evolving on a sort of good cause basis I mean, capital cases at the time the Constitution was adopted were tried within 6 months, right? The standards of how to try those cases were obviously different. And as more contemporary thoughts about that have arisen, it's become the standard that they require more. And so why wouldn't Speedy be flexible to accommodate that?
Well, I don't know why it would or why it wouldn't, but that's not been what's happened. We don't have a separate criminal rule that says that. We don't have a separate statute that says that. We would bend the Idaho Constitution until it breaks to make it say that. I'll give you kind of an example. During the time of COVID, when the Supreme Court told the speedy trial rights, it did that based on a national emergency. Court orders were issued. I am not saying whether I agree or disagree with that, but that's something that happened. And I think one of the cases the state cited in its response brief, State versus Ish, I think that particular case had 422 days of time between when the remittitor was issued and when the case went to trial, and that person asserted their speedy trial rights that whole time. That happened during COVID, when the court had its emergency orders during that whole time. So I think to say, well, it's a capital case and they're a lot different than they used to be, and they are, and they're a lot of work and they take a lot of time and investment, they do. But there's nothing that's been changed in our Constitution, in a court rule, in a statute, to say if it's a capital case, speedy trial, really, you just don't have that right. A person facing the death penalty just doesn't have that right. All of those rights exist. They all exist right now. And Mr. Kohberger had to choose between those rights. And I think the court can and should strike the death penalty in this case based on the
Well,
record
that would
here.
result in the death penalty being struck in every case.
Your Honor, if that's the way it is, because our clients collectively in the state of Idaho, when you have a capital client, if that's the case, then that's the case. I mean, we have been doing
The Constitution is flexible enough for the Supreme Court to itself say, well, we can pause that right, and we can expand that right based upon the circumstances, i.e. COVID. Why can't it expand the time that speedy is measured by constitutionally, given that evolving standards have required more time to present a capital case and measure it against that?
I would say that I don't know whether they can or they can't, but they have not. And that's the critical area. I would say the Supreme Court probably would believe it could do that, but it has not done it. And I would say they would believe that they could because they did so during COVID. But that hasn't happened. That has not happened.
So you think that the Supreme Court would likely say, well, as opposed to interpreting the constitutional right more broadly to apply over the, be more flexible given how the defense of capital cases have evolved, they would be more likely to say, well, we're just going to not have any capital cases, period.
I don't know if they'd say that or not.
Well, that's what
But
you're asking me to say.
I'm asking you to say that. I'm asking you to do
My job as a
what,
district judge, if there's not an issue that has been decided by the court, is determine how that court would decide things.
well, I think you can consider what Judge Boyce did in the Vallow case. And that had to do with discovery that counsel didn't have enough time to review and to prepare for, and it would have disadvantaged the client. And so Judge Boyce in that case struck the death penalty.
That was as a result of the state having failed to provide the information violating its court order. And then the remedies were, well, do we push trial back or not? And the choice that Judge Boyce gave the defendant was, well, we can go to trial, but I'll remove the death penalty because a lot of the discovery related to that. Or we can continue the trial for you to review that. But so you can either go to trial with the death penalty, without the death penalty now, or you can expand it with the death penalty. One defendant chose one and the other defendant chose the other. In this case, the decision to waive Speedy is not as a result of, as I understand it, a violation of a court order by the state.
It was as a result of a court order. And when we waived Speedy, we advised the court and counsel that this motion this day was coming. We don't think it's appropriate to force somebody to choose between competing constitutional rights. Lori Vallow had not ever waived Speedy trial, and so she had the choice to waive Speedy or not face the death penalty. And we think that since we were forced to choose between rights, those should be reinstated and the court should strike the death penalty.
Thank you.
Thank you, Your Honor. So not only can the Idaho Supreme Court do that, it's already done it. The Idaho Supreme Court has said that we interpret Idaho's Constitution for speedy trial the same way that the federal Constitution is interpreted under Barker. There's one exception that has no application here. And so it's an individualized test based on 4 factors, and you're really looking at kind of the overall reasonableness of the delay. I would direct the court specifically to the Langford case that just came out last year. The Idaho Supreme Court walked through the difference between the 2 constitutions, explained how they operate, and then found specifically in that case that they charted out how many delays there were, what the delay was for, who caused the delay, and then was it reasonable or not. And they found, they said, in sum, most of the delays here were precipitated by Langford's own actions. In the case of the last and longest continuance, the delay was reasonably necessary to allow new prosecutors and new defense counsel time to prepare for trial. So they found that's a reasonable, under the Constitution, that is a reasonable delay. So there is no choice here. You don't have to choose between speedy trial or effective assistance of counsel. You can have both. I think what the defense is saying is they've lost their statutory right to 6 months, which they do lose if they take an action to delay the trial at all. But that's not a constitutional problem that they have to give that up if they want to maintain their constitutional right to effective assistance of counsel. Now, in this case...
Well, and that was my point in, perhaps not well stated, is that it seems what this defense is trying to do, and perhaps you can comment on whether I'm saying this correctly, is to engraft what was the territorial law, which is that a case had to go to trial within at that time, courts were held in sessions, calendar sessions, right? I think there were 2 sessions a year or something like that. And that was the speedy right. And then we had the Constitution that doesn't, necessarily give us such a fixed time frame. But the argument is, well, because that was the territorial law at the time, therefore that's the constitutional right. And it is engrafting that statutory construct to mean the constitutional right.
Potentially, Your Honor, though I'm not sure that's exactly, because my understanding of the pre-Constitution statute was that it was based on kind of the circuits and when they came, and we don't do that anymore. And so that time frame just doesn't make sense today. You wouldn't be able to just engraft that in the Constitution and apply it today because...
Well, my point is that's, I think, what the defense is arguing, essentially.
Yeah. Yes, Your Honor, but the statutory right they're pointing to comes from the new statute that was passed in 1980 that gives the 6-month time period. And regardless of whether they want...
The argument that the 6-month is functionally equivalent of the twice-a-year circuit.
If that is the argument, I don't think that it gets past the Idaho Supreme Court has said, no, it's not. So... under the Idaho Constitution, we use the Barker test. The crux of the matter here is that the defendant didn't have to waive his constitutional right to a speedy trial. He did. He did so under advice. He did so in writing. He did so knowingly, but he didn't have to. The trial could have been continued, even at his own request, without him waiving that right. He waives it statutorily by moving for a continuance or to ask for more time to prepare, but he does not waive it constitutionally. If he did, then most of this Langford analysis would have been completely unnecessary. But instead, at the end of the day, when you do finally get to trial, the reviewing court looks back and breaks out segments of time and says, whose fault was that delay? And as the court said in Langford, many of the delays were because of Langford, and so they don't count against the state. But the court easily could have said, well, he asked for a delay, so his constitutional right was waived. But they didn't, because that's not how it operates. So the real problem here, I think that the defense is grasping with, is that they didn't need to waive his constitutional right, but they did. So, there's not much the state can say other than that wasn't required. The Constitution not only can be flexible, the Idaho Supreme Court has held that it is in fact flexible. And one of the reasonable, a proper reason for delay is to prepare for trial. And that means this is not a choice that has to be made by any defendant. It didn't have to be made by this defendant, but he chose to. Unless there are any further questions. Thanks.
Just briefly, Judge, we're not trying to graft in a time into the Idaho Constitution. We're looking at the word, the guarantee for a speedy trial, and trying to figure out what the word speedy means. And so
Well, doesn't speedy mean the Barker test?
at the time the Constitution was written, I don't think it did.
But isn't that what the Supreme Court has said it means?
I think our Supreme Court does agree that it's the Barker
Again,
test.
I think I probably can dispose of a number of motions by simply saying that the defense asks me to do X. Doing X would violate the binding precedent of the court. Denied.
I think if I was here saying dismiss the case based on a speedy trial violation, I think that's exactly what the court would do. This is a little bit different. We're asking for the court to set the case back to the point where we had to choose between constitutional rights and to strike the death penalty. In our case, this is the last point I'll make. In our case, we signed a waiver of speedy trial, and it was a form, I believe, that was generated by the court. It was signed on August 23rd, 2023. Mr. Kohberger signed it, and I assigned, with the parentheses, attorney for the defendant. And in that form, and remember, our scheduling order said you have to do it by this day, or you don't get a continuance, you're just going to trial. We gave up the right to, under the United States Constitution and the Idaho Constitution. And I have a printed copy, but I know the court probably has the entire court file. So that's it.
All right. That, along with the other motions, will be taken under advisement. Let's take a lunch break.